Good morning. We're here for the non-discrimination ordinance work session. I want to welcome everybody to today's conversation. The purpose of the workshop, again, in consultation with the attorney, the law department will take a few moments this morning to read through the draft ordinance. After the draft ordinance is presented to us, the commission will have an opportunity to ask clarifying questions. Today, our time is not intended to offer changes to the draft at this point, but on the other side of our conversation today, pursuant to commission action, we will then schedule public hearings around the draft ordinance based on the previous motion that the commission made. And so with that, I will turn it over to Attorney Brown for opening comments, and then he can hand it off to Attorney McClain.
Good morning, Mr. Mayor and commissioners, as well as the public. This workshop was set and ordered by the commission for the introduction of a draft of a possible anti-discrimination ordinance. This draft is for discussion purposes only and has not been approved by the commission, but it has been approved for presentation in a form of a workshop. This draft is not intended or deemed to be final or a recommendation. Presenting the draft that the law department has made will be the law department's senior attorney, Zena McClain. She will present this draft. Our goal will be to help you understand the different components of what an anti-discrimination ordinance would involve, to highlight the procedures, and also for you to take a look and take note of the resources that would be required if you decided to go forward with this draft. But I think there's no one better to present this to you than our senior attorney, Zena McClain. So if it's okay, Mr. Mayor, we would like for her to be able to speak.
Absolutely, Attorney Brown. I believe we're ready for her to share her screen and proceed with her presentation.
Can you all see the screen?
Yes, ma'am.
Yes, ma'am.
Not yet. There we go.
Okay, good morning, commissioners. Today I am going to be discussing the first draft of the Anti-Discrimination Ordinance Workshop presented by the Augusta Law Department. The objectives this morning are to provide a general understanding of what an anti-discrimination ordinance could look like. Also, it is to provide you an overview of who is covered by this ordinance, what is and is not permitted, and how complaints could be handled. Some of you may be asking, what is an anti-discrimination ordinance? Well, an anti-discrimination ordinance is a piece of legislation enacted by a municipal authority designed to prohibit discrimination against certain classes of people. Hopefully you all have had an opportunity to review the draft ordinance that was distributed, and you probably have seen a number of terms throughout that ordinance. There is a definition section. Age is defined in the ordinance. A business is described in the ordinance. A complainant means any individual that files a complaint pursuant to the article. Compliance Department, of course, is the Augusta, Georgia Compliance Department's Equal Employment Opportunity Division. Disability is defined within the ordinance. Discrimination Discriminatory practices, discrimination, all of that is defined within the ordinance as well. Employee means any person employed by or seeking employment from any business within Augusta, Georgia. Also, employer is defined within that draft ordinance. And it means any person or business that employs one or more employees in Augusta, Georgia. Gender identity is defined. And this particular definition is a rather broad definition of gender identity. Some of you may have reviewed other ordinances that is narrower, but this particular definition of gender identity is particularly broad. Marital status, mediator is defined. Military status, national origin, place of public resort, accommodation, assemblage, and amusement. Religion, religious organization, and respondent means that the individual or business that is accused of violating this article in the complaint. And sexual orientation. Again, sexual orientation, this is a rather broad definition of sexual orientation, and some ordinances have a more narrower definition of sexual orientation. Protected classes, race, religion, color, sex, disability, national origin, ancestry, sexual orientation, gender identity, age, military status. Perhaps some of you have reviewed other ordinances, and I just wanted to point out that a protected class that's not mentioned here is pregnancy. I have seen some ordinances that include pregnancy as a protected class. This particular ordinance prohibits discrimination in public accommodations, employment, and the sale or rental of property. The unlawful practices described within this particular ordinance. It's an unlawful discriminatory practice for a business because of a person, and these are the protected classes: the race, religion, color, sex, disability, national origin, ancestry, sexual orientation, gender identity, age, or military status. To refuse to hire or employ such person, or to bar or discharge a person because of those protected categories, or to otherwise discriminate against those protected individuals in compensation, terms, conditions, or privileges of employment, or to follow an employment procedure or practice which in fact results in discrimination, segregation, or separation. Then there are the unlawful practices regarding the sale or rental of property. It's an unlawful discriminatory practice for a business to discriminate against any person in the terms, conditions, or privileges of sale or rental of property. Because, again, those protected categories or classes of individuals, or to discriminate against any person and such person's use or occupancy of rental housing because of, again, those protected classes of individuals. Unlawful practices in public accommodation. It shall be an unlawful discriminatory practice for any business, as defined herein, being the owner, operator, or manager of any place of public accommodation, to refuse or deny or make a distinction directly or indirectly in offering its goods, services, facilities, or accommodations to any person as covered by this article because of those protected categories, classes of individuals. I want to point out that notwithstanding the above, nothing in this article shall be construed to prevent any business as defined in this article from offering, affording, or providing additional benefits or additional discounts to a person because of such person's military status. Then there is the retaliation provision of this particular draft ordinance, which makes it an unlawful discriminatory practice to aid, abet, incite, compel, or coerce the doing of any act defined in this chapter as an unlawful practice. To intimidate, harass, retaliate, obstruct, or discriminate against a person in any manner because such person has complied with or proposes to comply with the provisions within this particular ordinance, filed a complaint with Augusta, Georgia's Compliance Department, taking other legal action, testified or assisted in any proceeding or investigation, or opposed any practice made an unlawful practice under this chapter, or to apply any economic sanctions or deny accommodations or membership privileges because someone has complied with the provisions of this ordinance, or to coerce, intimidate, threaten, or otherwise interfere with any person in the exercise or enjoyment or on account of his or her having exercised or enjoyed or having aided or encouraged any other person in the exercise of any right they have under this particular ordinance. Now let's talk about what's excluded. And the exclusions are specifically noted within the ordinance. Religious or associations, corporations, or societies employing an individual of a particular religion to perform work connected with the performance of religious activities. That's not a discriminatory practice. Or an employer using a bona fide affirmative action plan or a bona fide seniority system. Or an employer refusing to hire unqualified or incompetent persons. Religious organizations limiting non-commercial accommodations, advantages, facilities, memberships, or privileges to persons of the same religion. Also not a discriminatory practice. An employer requiring an employee to adhere to reasonable and equitable dress or grooming standards. Or a business failing to make changes to a facility that would require a building permit. And we're now going to get into the meat of the ordinance, the enforcement provisions. If someone believes that their rights have been violated, they must first file a complaint, and the complaint has to be filed within 90 calendar days of the alleged discriminatory practice. Some ordinance enlarge in that period of time. Some shorten it, but generally 90 calendar days is pretty consistent along the lines of those that I've studied, those ordinances that I've studied. How to file a complaint? Of course, any person believing that they have been, subjected to a discriminatory practice that occurred in Augusta, Georgia, can file a complaint. How? They have to file an original and 2 copies of a complaint with the Augusta, Georgia Compliance Department. And of course, this is just a draft of an ordinance, and you as the commissioners, you can, suggest other ways that they can file it, but this particular ordinance suggests filing an original and 2 copies with the compliance department on a form that's going to be provided by the compliance department. in how, the manner of filing. It has to be filed by personal delivery or certified mail addressed to the Augusta Compliance Department. Now, what happens after a complaint is filed? Of course, it has to be served, your service of process. Within 14 calendar days of receiving the complaint, the Compliance Department will serve a copy of the complaint upon the respondents via certified mail, return receipt requested. Now, there is an investigation and mediation process involved in this. Within 45 days of receiving a complaint, the Compliance Department will conduct an investigation. And the investigation can be made by field visit, written or oral inquiry, conference call, or any other method or combination deemed suitable. And it's at the discretion of the Compliance Department. Upon investigating the complaint, the Compliance Department will refer the complaint to a mediator for non-binding mediation. The notice of mediation will be sent to the complaint and the alleged violator 10 business days in advance of the scheduled mediation. Noted, participation in mediation is voluntary. However, the case will be dismissed if the complainant does not attend or show cause for not participating. Any mediation will be conducted in accordance with the procedures established by the mediator. So the mediator will establish the procedures that are involved in the mediation process. If within 15 business days of the conclusion of the mediation, either party notifies the Compliance Department, and it has to be in writing that such person is dissatisfied with the results, or if the respondent, and that is the person accused of the discriminatory act, fails to participate in mediation, the complaint shall be referred back to the Compliance Department, and the Compliance Department will then cause a copy of the complaint to be delivered to the Marshal's Office of Richmond County. And this is where the judicial process begins. Within 7 business days of receipt of a copy of the complaint from the Compliance Department, the Marshal's Department or his designee will cause a copy of the complaint and the summons to be served on respondent. Excuse me? Was there a question? Okay. The summons will direct the respondent to appear before a judge of Richmond County.
Mr. Mayor.
Commissioner from the 6th, do you have a question or do you want to wait until the presentation's done?
I'll follow your lead, whatever you suggest.
Yeah, let's let her complete the presentation and then we'll just take all your questions, okay?
Thank you, sir.
Yeah, thank you.
We have a few more slides to go, Commissioner, so.
Yes, ma'am, no problem.
Okay. Again, the summons will direct the respondent, and again, the respondent is the person accused of a discriminatory act, to appear before a judge of Richmond County Civil and Magistrate Court on a date and time certain for preliminary determination hearing. However, prior to the preliminary determination hearing, the marshal, or again, his or her designee, will cause a copy of the original complaint and a copy of the summons and proof of service of the complaint and summons to be filed with the clerk of the Civil and Magistrate Court. The respondent may then file an answer to the complaint at any time prior to the preliminary determination hearing. However, filing an answer is not mandatory, and no adverse inference will be drawn if the respondent decides not to file an answer. And we're going to now talk about the determination hearing. What happens at the determination hearing? At the preliminary determination hearing, the civil and magistrate judge will be reviewing the complaint and the answer to make a determination whether the complaint conforms with requirements within the article, whether the proceedings are preempted by federal or state law, and whether the complaint demonstrates facts sufficient to show cause of a violation of the article. And upon such determination, the civil and magistrate court judge will enter a written order expressly stating the determinations made and either dismiss the complaint or schedule the matter for trial on the merits of the alleged violation on a date not less than 60 days from the date the written order is filed. So within 60 days of that written order, a trial will be had. In the event the civil and magistrate court judge determines that there is probable cause and the solicitor of Richmond County Civil and Magistrate Court determines that there is just cause to proceed, that an alleged violation should be prosecuted, the solicitor shall, within 15 days of the date of the written order is filed, draw up and file with the clerk of civil and magistrate court and serve upon the respondent a formal accusation or similar charging instrument. And for purposes of this particular section, service shall mean either personal service or service by certified mail, return receipt requested. Now, the burden of proof is by preponderance of evidence. This is a civil matter, so it's by preponderance of the evidence for your benefit. This ordinance will not be construed to invalidate, restrict, or deny any right or remedy of any person that they may have under federal law, and it does not preclude any cause of action in court otherwise provided by a violation of any person's civil rights. Also, this ordinance is not construed in any way to violate any person's rights under the United States Constitution or the Constitution of the state of Georgia. And let's talk about the penalty. Here is suggested that any person or business found by a civil and magistrate court judge to have violated any provision of the article will be subject to a civil penalty, $500 for the first violation and $1,000 for each subsequent violation. However, any person or business found by the civil and magistrate court to have violated any provision of the article more than once within a 12-month period will be subject to a revocation of his or her business license. Also, a violation of this ordinance will not be deemed a crime. And now, time for questions or comments. And if Jeff, if you just stop sharing my screen, that will be fine. Okay, thank you.
Yeah, thank you, Attorney Heyman. We've got a couple of questions. All right, we're going to go in this order. I'm going to go to the Commissioner from the 6th and then the Commissioner from the 2nd.
Thank you, Mr. Melner. What I just did, let me try to get back over, because I ain't not trying to hide, I don't think.
Okay, you were back just a moment ago.
Okay,
All right, there
okay.
you go. You're good. Thank you, sir.
Thank you, sir. Enjoyed your presentation, Attorney
Thank you.
Hyman. McLean.
You can say McLean. You can say McLean.
Yeah. But one question I had was the part about the compliance department, and when the person who filed the allegations didn't like the compliance department outcome, then they decide to say that, well, at that point they give them the opportunity to within 7 business. I mean, to send it to the compliance department, deliver it to the marshal's office within 7 business days. The marshal's office or someone he designates delivers this person, some of those persons to court. And so what I'm trying to figure out is what normally happens here in the event that there's a violation. Normally, when the marshal's office is involved, how does a person normally come to court? We know at the end, the magistrate courts, whether it's civil matter or whatever, then the judge makes an ultimate decision. So at this point, we are empowering the compliance department to deliver this to a person to show up in court? I mean, what are we doing here? That's what I'm trying to get. That's what I'm trying to get my mind wrapped around.
Okay, I believe Mr. Brown wants to answer that question.
No, you can go ahead if you like, Ms. Attorney McLean, but if I need to, I will.
Okay.
I think I understand the question.
You're saying, are we requiring the compliance department to?
Yeah, let me try to read it if you don't mind, because I could be just misunderstanding my part. So the
Okay.
complainant shall be referred back to the compliance department. The compliance department shall cause a copy of the complaint to be delivered to the Marshal of Richmond County within 7 business days of receiving a copy of the complaint from the compliance department. So there's a process that's going now that's leaving because the person, I think in many ways, was not satisfied. So now it's headed to the Marshal department at our request based on the policy that we're establishing. So I'm saying, what's the difference in that that's in the open market? What's happening here different at that point? Because the Marshal is going to see the person to come to court.
Yeah, if I may, I don't think that's much different than what happens in code enforcement. The compliance department does not serve a person, tell them to come to court. The compliance department, once they determine that a complaint has been valid and that mediation has either failed or not participated in, then the forum in which this complaint gets resolved will be in court if mediation is rejected or is unsuccessful. The compliance department, as you read, would deliver to the marshals the complaint. The marshal would prepare a summons, and as they do with code enforcement, and serve the respondent and letting them know a date and time they have to be in court.
Yes, okay, let me try. I think you said something that's going to help me here. And that is, and I wasn't assuming that the compliance department was doing that as much as I was just kind of watching a process. But when you said the code enforcement, remember code enforcement are certified peace officers in many ways. So we're going to deputize the compliance department to do the very same thing. Because when that happens from the code enforcement, they are certified peace officers or some officers of the court. So are we going to do the same thing for the compliance department?
I will have to look into that present system with the code enforcement to answer that, but we will mark that down as an issue that needs to be addressed.
Thank you, sir.
All right, thank you.
Commissioner from the second. Unmute yourself, sir.
Okay, I'm sorry.
No worries.
My question is, how would or do this ordinance affect employers or organization that already has an established program or system to address these matters?
How would it?
Yeah, how would our ordinance affect those company policies, like the federal government EEO system? How would ours affect them?
It wouldn't. It has nothing to do with any organization's internal policies or procedures. This is separate. It would not preempt state law or federal law. It works just
in addition to.
Yes. Mm-hmm.
Okay, thank you.
Thank you, Commissioner. All right, going to the commissioner from the 10th and then the 4th.
Thank you, Mr. Mayor. Who would be doing the mediation, and what training will the mediators have to make them, be able to make these decisions?
Yes, Commissioner Clark. Of course, this is just a draft, and you commissioners can decide what qualifications you want that mediator to be. You can put in the ordinance if you want a certified mediator, if you want to use a mediation, a particular mediation program, perhaps attached to the courses. I'm new to this area, so I'm not sure if they have a mediation department with the court, but you can draft that particular section any way you like. It's pretty narrow right now, but if you wish to have it expressly stated that it's supposed to be a certified mediator, you can put that in the ordinance.
Okay, thank you for your answer. That's all I have at this time.
Ms. Mayor,
I believe-
also, I would say one of the elements that we would have, I could not envision a mediator who does not have sufficient experience in employment law. We don't want, simply being a lawyer would not be enough for them to be a mediator. They do need to be well versed in EEO, equal employment opportunity matters. That's the type of person we would target for that. But as Attorney McLean said, the guidelines for those mediators, if the commission wants to go forth with the program or with the mediator, then the law department will offer to the commission for consideration those guidelines. Then the commission will either approve it or say, no, we want this or we want that. Then we will set those guidelines up. But
Okay,
in that this is a draft, we didn't want to work too deeply on something before we even know that it's a go.
understood.
Commissioner from the fourth.
Thank you, sir. I want to go back to what Commissioner Sung was asking about. And the attorneys gave an answer, but I'm a little not complete with that answer. When the code enforcement does a summons, that summons has been issued by a judge. They don't send anything to the marshals saying go do this, to my knowledge. All summons and things where code enforcement goes to court and request the judge demand that person or order that person to appear. So same thing with the going back to what my colleague was asking about, that same process. We would need some kind of process to be able to say to a judge or order that person in the court, or we have filed a civil case. I just don't see where within this ordinance you can just, after you investigate something, then you can demand that they appear before a judge. This ordinance is not something, as I have stated earlier, that I'm not very much in favor of. And the more I listen to it, the more things I become concerned about. Not saying it can't happen, but I'm just extremely concerned about these same things and these issues. So I think first off, that need to be closely looked at is how you get somebody before a judge. Thank you.
Attorney McLean, Attorney Val, I'll yield to you to respond to Commissioner Sykes.
I do agree with Commissioner Sykes to the extent that I think this matter needs to be looked at more, but just for his information, code enforcement does not go to a judge to get a summons to tell someone to come to court. I just verified that again with the, I guess the longest standing code enforcement person, which is Rob Sherman, a few minutes ago. But so that we don't get bogged down in it, I will agree that the whole that part of it still need to be fleshed out and looked at, so we make sure that we don't do anything without authority and that's constitutionally void. So we will look deeper into that situation.
Thank you, Attorney Brown. I'll pose a question in relationship to that before I go back to the commissioner from the 6th, and that is, other cities, they certify mail the request to appear. Is it not true we could do the same?
Yes, we do have that option throughout. In-house services could be effectuated by certified mail.
Thank you. Commissioner from the 6th.
Yes, I think what I'm talking about really, and it's really talking about the point where we found code enforcement go out and they write a ticket and put on the person's door. That starts that process when they find them in violation. That's what I'm talking about. And the reason they're able to do that because they're certified by the courts to do that. And that's what, so I'm talking about that in the very front end, because the very front end here is saying within 7 days going to the marshal's office. So my question really is, the simple part of it is, are we going to give them some type of certification by the will of the courts? You know, if we stay the courts here to be able to do that. That's what I'm saying, because currently just them sitting in the compliance department, I wouldn't think they would be able to which comes about to the same magnitude of writing that ticket and saying you need to appear in court. So I'm saying, so there has to be, I believe, some sense of certification. I'm talking about the very front end. I think Attorney Brown, I think he's shaking his head and you see very clear what I'm talking about now, if it wasn't clear before.
Attorney Brown, in light of what the commissioner from the 6th is indicating, my question to you is it not true that the code enforcement process is an active one in regards to, again, how they post and position with regards to violations? What we're talking about regarding the NDO is more of a passive approach, where there has to be an alleged violation that someone then comes and says, I want to file a complaint predicated on an alleged violation. Code enforcement is much different in that it is an active process.
That's correct. The code, this proposed ordinance, the complaint will be filed by the alleged victim. Code enforcement is looking out for general public welfare as a police officer would do, because a crime is considered, or the violation is considered against society at large. And this ordinance would address personal or individual grievances that is had against a business for an alleged violation that the city, by this ordinance, is saying that you cannot do.
Thank you for that. All right, I'm going to drop down and pose another question, and this is in the enforcement section to both of you, and that is a clarifying question for section A and C under enforcement. The former, i.e. section paragraph A, states that an aggrieved party needs to make, sign, and file an original and 2 copies. The latter, i.e. paragraph C, states a form will be provided. Can the differences in this process be explained?
It's just not clearly defined. It's supposed to be consistent. So the original complaint would be the form that is provided by the compliance department. However, somewhere in that process, 2 copies of that original will have to be made. And the reason why the copies need to be made is because one has to be served on the respondent, one has to be kept by the complainant, and the original remains with the compliance department.
Follow-up question, Attorney McClain. Is it not true then that the intake department could make the copies and distribute them as necessary?
That is correct, sir. So that, as the revisions are made, that can be more clearly defined within the policy, yes, within the ordinance.
Okay. And one more question. One more question before we pivot back to our colleagues here. And another clarifying question. In other municipalities across the state, the complaint is filed with the law department, city clerk, or city manager. Is there a rationale why this will go to the compliance department in your draft?
No rationale. Of course, the commissioners can decide what process they want to undertake here. Yes, many of the ordinance first begin with the complaint being filed with the clerk of the commission or the clerk of council. And so it was just because we have a compliance department in an EEO department, it was just suggested that it be done that way. But of course, it's just an initial draft. So it's whatever the commissioners would want the process to look like.
Thank you. Attorney Brown.
Yes, also too, if it's filed with the clerk's office, we thought instead of moving the complaint around once it has been delivered to the government, we file it with the clerk of commission office, then the question would be who is going to do the investigation? Some of those other ordinances where it's not filed with the compliance office, they may have another unit to handle the processing of that complaint. They may have hearing officers. We did not go the route of having hearing officers. And logically speaking, the compliance department would be skilled with people, staff with people with EEO skills in terms of investigating a complaint. But there's nothing compelling that it has to go to the compliance department. It could go to law, it could go to others. It depends upon how the commission would want to staff it, which is an issue that we do want the commission to think about. As you go through the ordinance, think of at every juncture, what human resources or financial resources will be needed to make this program work. It doesn't just work by passing the ordinance. We need to think about who's involved. Will we need to add someone to the compliance department? How much our mediator is going to cost? Where will the mediators meet? Additional duties to the marshal, additional duties to the solicitor of the civil and magistrate court, duties for which now she is not paid because she is paid narrowly for the activities she actually does. She is not full-time staff there. And also now the additional burdens on the civil and magistrate court. All those things have to be fleshed out if the commission decides to move forward. And I'm just asking you to keep that in mind to make it part of your consideration.
Thank you. Commissioner from the first.
Thank you, Mr. Mayor. I think Attorney Brown answered my question when he was in his last comments. You know, we were talking about which department would be in charge of this. But the question I had was, would there be a need for new staff? Would there be some type of cost associated with new staff in either office, regardless of where we place them? And you pretty much answered that question for me. I do have a question in regards to the protections. There was there was a section here where we discussed the protections. It's unlawful to discriminate against certain traits, race, color, religion, national origin, sex, orientation. Would this ordinance protect against discrimination where hairstyles, hair colors, and things of that nature is concerned? There was, I believe the section said that folks would be exempt from if a business was asking them to comply with reasonable grooming and reasonable dress code. I guess what the overall question is, what are we considering to be reasonable grooming standards and reasonable dress code standards? And in that, would hairstyles, dreads, braids, would that be protected under this as well? I know that question was kind of all over the place.
That's a good question, because I have read, I think it's maybe Atlanta's ordinance is expansive. It covers a lot of categories. And there's another municipality that does include protection for people with natural hairstyles. So if the commissioners decide that they want to specifically address that with this ordinance, you can do that. There's a lot you can do with these ordinances. And so I would just suggest if you want to expand those categories to compare other municipalities' ordinances to see what you may want to include as a protected category. But to answer your question, no, as it's written, it would not cover that, but you can add it.
Okay, thank you.
Administrator Donald, I think you might be able to shed some light on that for us. You've got real world experience in terms of what's happening in the metro area and some work that you've done before. Can you speak to that?
Well, yeah, I mean, I think, in South Fulton, we passed the Crown Act and in serving over labor, I mean, we looked at some of those protections. And I think one of the things that I've highlighted is that you haven't had to really bring a ton of these cases forward, but those folks who are impacted are usually some of our most vulnerable citizens. So I think as the commission, if the commission does support moving forward with the ordinance, I do think that it would be good as you go through the public hearings to get that feedback on specifically hair, which is one of those things that has not been addressed in many of these ordinances, but is one of the areas where folks feel like they receive the most, I guess, transgression or discrimination. But there are some other areas. Actually took some notes the other day where I just noticed there were a few areas where you may want to just look. I saw the hearing officer was also removed. So I know that could be a benefit to address some of these key issues and stop them from moving forward. And then I think just that clarifying language that adds protections versus making it a more restrictive ordinance. So I mean, you wouldn't get into those things today, but I do think you wanna look at those areas. And I think y'all are right on target talking about what department should these things be vetted by, because I think you're going to need resources depending on how the ordinance turns out. So you want to make that the smallest cost to the city, the biggest bang for your buck.
Thank you, Administrator Donald. I appreciate the comment around the hearing officer. That's an important facet that certainly mitigates the need for additional human capital, because they are kind of an on-time, on-call type of situation. Commissioner from the 6th.
Thank you, Mr. Mayor. And
Yes.
I don't know, I don't think we mean this literally, but I'm going to say it in that spirit to just try to make my point here. When we're saying to continue to do something to draft a potential or a broader ordinance around us, number one, it concerns me, how would we get there by that, talking to all of these principles? I know we are talking about the public in law, doing some public hearings around it, which is a good thing. But also you're talking about, preparing your compliance department. I'm just looking at it as it's currently written just to make my point here. You're talking about getting involved with the marshal's office. You're talking about talking to your civil and magistrate court judges and things of that nature to try to make sure. So my point is, I don't think we even at a point that we can continue to move forward and draft an ordinance up until we hear from the inside principals and the public and things like that. I think we still got quite some way to go before we get to those points, because all of these parties has to be addressed. What does it cost for their caseload, especially when we realize from a court perspective, the courts are backed up. They may be 2 years behind now. And they're going to take on this burden here. We're talking about mediators and costs retain, who's going to do that? And we got mediators, hearing officers. Well, those hearing officers, they may give us, say, well, $75. Let me give you an example, just throwing something out here. $75, half an hour to have this. But in the meantime, is there a retainer for available when you need a hearing? So there's a lot of other things here that I think needs to be worked out before we, just really talk about continuing on this ordinance itself. Thank you, Mr. Mayor.
Commissioner from the 6th, I couldn't agree with you more. This does appear somewhat cumbersome when you look at the policies that are in place in all of the other 7 cities. They look for an opportunity to be to be efficient in terms of the execution, which is why they employ the use of hearing officer, a mediator, and then you get a result. Really a 2-pronged approach: hearing officer, mediator, and then you get a result. So we've got an opportunity to, certainly look at what those other 7 cities in the state have done and to effectuate our approach around those things and try to make it, again, as efficient as possible. Okay. All right. Anyone else? All right, Commissioner from the 1st.
Thank you, Mr. Mayor. I have a question for the administrator. I want to, say that I will echo Commissioner Hassan's concern about just the areas of this ordinance that we need to be able to make sure we have pinpointed answers for. I think that the nature of this, we don't want to, half bake a cake, and I don't think it's nowhere near us being ready, taking it out of the oven. So with that being said, Administrator Donald, do you have any recommendation on what a path forward could be to get this ordinance to a place to where some of the questions that we have are answered, specifically around some of the departments that Commissioner Hassan mentioned, your marshal, your court officials, your compliance. What do you think a good path forward would be to get this to a place where we'll be ready to decide on it?
Yes, I think that both the mayor and Commissioner Hassan both really expressed it without putting a timeline on it.
Right.
You know, I think you've got to take some time first, and I think the commission, you know, can guide us on this. But we do, as the ordinance is written, I think one, we need to establish a way to get some written feedback from our commission, whether it be one-on-one conversations or whatever it is, to make sure your concerns are received, I'm assuming by the legal department who's drafting it, so they can consider those adjustments as they go forward. We probably also need to have some of those small group meetings with the marshal's office, with the solicitor and others, to get their feedback on both, you know, cost, whether they have the ability to take on these new items, because I don't think you want to create an unfunded mandate. You can create a law, but if you don't fund it, then it can't be implemented and executed. And so you want to find out what those costs are, as well as be able to identify what their needs would be to implement it. I think we could do that, I don't know, maybe 45 to 60 days or so. And then you go forward with, and maybe less, I think that's up to the commission. But then you also want to make sure you hear from the public, and not just our citizens. You definitely want to hear from them. I think you want to hear from them first. But you've got a very strong business community that is also very willing to partner and, you know, does a really good job of making sure this is not a humongous problem for our county. And so you want to make sure they have the ability to give feedback as well and give input to the ordinance. And, you know, I've had a chance to speak with both the Black Chamber as well as the Augusta Chamber, and they both, you know, I think are supportive, but want to make sure that, you know, it's not an overly cumbersome process. So I'd start with getting that feedback from the commission, move to those impacted staff, and then open it up through whether it's a survey, town halls, or whatever it's going to be, to hear focus groups, but to hear back from the public and the business community. And so the time frame in which we do that, I think the commission can assign it. I'm not prepared to, off the cuff, you know, determine whether this is something that's done within 90 days. And I definitely wouldn't want to add additional stress onto legal, who's kind of leading the writing of it. But I think that's the process and how long it takes. Either we can come back with a recommendation or the commission can assign it.
Thank you for that, Administrator Donald. I think what I'd like to do is hear from our law department about a time frame in light of all of what's going on. But more importantly, I want to ask this question that I'll pose to our council. In the draft, it speaks to the issue, and I've got a clarifying question. Revoking a business license in response to violation appears to be an extreme option as opposed to graduated fines. What's our rationale for that?
I believe there are, well, everything in the ordinance is really just a choice, because you have to put something out there to solicit something. We could not come with a blank page and ask you, well, what do you think the fine should be? So it's just that. So I don't think there's really much of a need for us to justify it, because we are not recommending it. We just put it up as an option. So if there are comments about, hey, let's look at another enforcement fine arrangement, the law department is fine with that. We're not vested into that. I do agree that taking someone's business license certainly adds a lot of teeth to the ordinance, but how quick you bite someone should probably be measured. But we really think that's a policy decision for the commission. We are not trying to make that decision. Bishop from the third.
You're muted, Commissioner. You're muted.
Okay, thank you, Mr. Mayor. I'm on here today because I'm representing City of Augusta, and I've gotten a lot of calls about this and emails, but in somewhat of a way, I see this as an embarrassment a little bit to Augusta, because it's almost it's used to encourage more complaints, and I just don't see in the long run it being something that's going to help us. I mean, we've got this city has a lot of nice prominent businesses. We got downtown businesses, and I see this as a way of hurting them more than helping the businesses because of these complaints. I just don't see it being a problem solving ordinance, but more of an ordinance that encourages complaints. And it's going to cost us more than it's going to save us. I wanted to put that out there and just let people know that that's how I feel. Thank you.
Thank you so much. Commissioner from the 6th.
Thank you, Mr. Mayor. Mr. Mayor, I'm hoping this will be my final comment about this. Don't y'all hold me to it, but this, I think based on, what the last 10 minutes has been, we've talked about some sense of timeline, and I would encourage us pretty much not to put a timeline on it. I think we're about to probably the most busiest. You get some real things done, Mr. Mayor, and that's not to minimize this. Please, I don't want to minimize what we're communicating about today. But you're talking about we're getting ready to have a retreat around how we're going to handle the budget, which seems to be quite different than we ever handled before. We're talking about dealing with, we know this year alone, we may get a check for $40-some odd million to aggressively spend, as well as to try to get the rest of it next year. And as well as some other things with the administrator potentially having staff on. We're in the midst of hiring a fire chief. We're in the midst of doing a lot of things. And that don't mean we can't do some of these things, but I would rather kind of just slow walk this and get it together as opposed to saying, well, we want to look at this back in 90 days, 120 days. Let's do a very thorough job on it. And if we don't get to the first of next year, it's fine with me. At least we know we done it right. Because like you say, Mr. Mayor, we do have some options out there. You got 7 cities. It seems to be, and this did not come from what all of received this morning. We already done some pre-investigation and realized that many of those cities have not thus far had any complaints. There's 2 ways to look at that. Maybe cities people are reluctant, there's really no problems. And we know there's always some level of discrimination. I just hate to see us sit here and consider putting a timeline on it and just slowly just trying to walk some of the stuff down, walk some of these issues down, and then make an informed decision. I just ask us not to put a 90. We want to look at something in 90 days, 120 days. I think we got a robust agenda coming up for the rest of this year, and I just want to be mindful of that as we have the conversation.
Mr. I appreciate that. We started this conversation 60 days ago, and we didn't put a timeline on it. What we said is that we continue to do the good work in light of, again, all of the initiatives that we're working on. I'm of the opinion that none of you would suggest by any stretch that we shouldn't do everything we can to protect vulnerable populations in our city. And that's the intent behind this. We mentioned 7 cities that have model legislation that we quite frankly can have in some instances taken those and incorporated those into when we began the conversation, a draft that was presented to the full commission at that time. And so what I'm cautious about is one, putting a date, time certain, but I think we can continue working on this. And as we continue working on this, working in concert with Attorney McLean, have something that we can bring back. She's done some good work here. I appreciate her presentation and the way she's put that together for us. And I think we can continue to do that in motion while we're working on the American Rescue Plan, what our efforts are around that, and any host of other matters to include a budget for 2022, because we've got the right resources and the right people working on stuff now, as opposed to where we may have been in the past. So I think we're in probably a better position than we've ever been as a city. And what I would ask and challenge the commission is, let's keep working on these things together at the same time that we're doing other initiatives, and not necessarily put a date certain on it. I do support that.
Thank you, Mr. Mayor.
Yeah, Attorney Brown.
Mr. Mayor, I believe, just as a parliamentary matter, in that this is a workshop, I believe that, kind of a path going forward, if so, would only be proper in a committee or commission meeting and not this workshop.
Yeah, Attorney Brown, I think that, what we've said is that a previous commission action was to have a public hearing. What I'm hearing is that perhaps we're not at that point yet, but that's what we were tasked with, having a public hearing at this time certain. What I'm suggesting is, in light of what we're talking about today, let's work in concert with Attorney McLean. And we know what those other cities have done. You've heard from our administrator who's talked about the components of it from the Crown Act that they passed in South Fulton. Atlanta incorporated that in their overall legislation. You've got Dunwoody, who's done some really good stuff. You've had Savannah, which I know our local business community has seen and saw that as a model for this business community as well. We've heard those comments. And so I think that we should just continue, even in a small group setting, having this work being done in parallel with all of the other stuff, because you've got different departments, finance and the administrator's office working on the budget. You got other outside entities, commissioner from the 6 who are going to be working on, the American Rescue Plan. And for us as elected officials, we need to be thoughtful about, from a vision standpoint, what we want to see and the impact we want to make in our city over these next 18 to 24 months.
Okay, sounds good.
Okay. All right, Commissioner from the 10th.
Thank you, Mr. Mayor. I'm in agreement with you on this one, that I think we need to continue in a work session for at least a couple of more, and then possibly a public work session. But what I would like to see happen going forward in the next work session is every commissioner, I'm quite sure, has questions that they would like to ask and statements to put forth. So I would like to see us in the next work session for each commissioner to have, 2 or 3 questions that they would like to put forth, and maybe a statement, and everybody to really get involved, because this has to be done. If we're going to do it, it has to be done correctly. It can't be rushed. It's got to be well thought out, and every aspect of the issue has to be taken into consideration. And if we rush it, we're going to get it wrong. So let's really delve into this. If we're going to do this, let's delve into it and take the proper amount of time to get it right. Thank you, sir.
Thank you, Commissioner. I'll close my comments with this, and I'll go to the Commissioner from the 1st. I go back to, we don't have to invent anything. There's model legislation that's out there. So we're not working in a place of where we got to reinvent something or create something from scratch. We have model legislation that's already been adopted, that's already been voted in larger cities and or municipalities. So we've got a framework upon which we could work so that we can, in fact, get it right. And so let's continue, again, having Attorney McLean work on that. The motion that was adopted by the commission previously during that 60-day window was to have a public hearing. So it would also probably be prudent for us to just get the public's input about the need for this in some form or fashion, and that could potentially help shape what Attorney McLean is working on. I'm going to go to the commissioner from the 1st, and then I'll close out with you, Commissioner from the 6th. Okay, you'll be the last comment, Commissioner from the 6th. All right.
Thank you, Mr. Mayor. I want to just say, I want to make just a quick comment that I don't think at any cost that this is a stab at our local businesses. I think we have some really good businesses. I think that at the end of the day, this is a really good opportunity to to let our position be known, but it's not a stab at local business. We have good businesses, and we just want to, I want to hone in on that, you know, as the business community may be watching in on this conversation, there's a general consensus that we don't have bad businesses here. But at any rate, that was the only comment that I thought would be necessary to make. And also just really thank the business community for what they've already done to kind of help us get to a point of equity and inclusion. But at any rate, I think that we've already established a pretty good understanding of what we should be doing going forward, taking our time to get this right, exploring public options, public hearing feedback, things of that nature. But again, at the end of the day, I think that we have a pretty good idea of how to move into the right direction. So thank you, Mr. Mayor, for the acknowledgement of these things, and I look forward to continuing the conversation. Thank you.
Thank you. All right, Commissioner from the 6th, close us out.
Yeah. For the record, Mr. Mayor, and I'm going to apologize to you in advance if I'm wrong on this, but if I remember the vote correctly, it was a vote to have a public hearing. I'm sorry, to have this workshop. I'm not sure a vote was tied to that as part of that too. I could be wrong on that. I'd like to ask the clerk to send us out what the motion was to try to make sure of that before we try to something saying that it was a public hearing. But like I said, if I'm wrong, I apologize right now in advance, but I don't remember it being there. If I'm wrong, appreciate it. I can stand corrected.
Yeah, thank you. That was when we first started this in the early 60-day period. There was a motion and the commission approved having a public hearing with regards to this. Yeah. All right, so I think Attorney Brown has asked, I think it's important and prudent for Attorney McClain to continue to work, taking those other cities as models. And as we continue, we'll set another time for another work session and go from there. Okay.
Thank you.
All right, fantastic. All right, thank you, everybody. Thank y'all so much.
Thank you, Mr. Mayor. Thank